Pace versus Blue. Excuse me just a second. Y'all are who?
Your Honor, I'm Janice Green, corporate representative for Blue LLC, and my husband Martin Green, the other.
All right, thank you.
Please the court. I'm Burton Green. I'm an attorney. The appellant, Mr. Pace, retained me 2 weeks ago to appear on his behalf for oral argument. And we filed a notice of supplemental authorities this morning at 8:30. I don't know if it's been provided to you. I'm going to make some reference to those authorities on this issue.
Have you given them to the other side?
They were mailed to the other side.
Mr. Green, I'm not going to let you argue something that the other side hasn't seen.
Well, all right, Your Honor. It was my understanding that they weren't.
8:30 in the morning of oral argument is too late to file a supplemental authority unless the other side has been supplied with a copy of it and had an opportunity to review it. The court hasn't even seen it. There's no point.
All right. The case, as we perceive it at this point, is not. I'm sorry, Your Honor. My clock is not moving. Am I supposed?
It will be in a second.
Okay. All right. Thank you, Your Honor. The record that we're before you on is primarily a record based on the actions taken by the lower court procedurally and on the complaint. Now, we're here on a judgment that was entered against Mr. Pace individually and against the Earl H. Pace Irrevocable Trust. The case proceeded before Judge Turner on most of the procedural issues, and then Judge Dugan heard the trial itself. And what Judge Dugan did, and this is clear in the record, transcript of the court's ruling, 1 through 11 on page 8 of the transcript, Judge Dugan was expressing who he believed were the parties before him for trial. And what he said, and this is at his oral announcement of his ruling, and I'm quoting from the transcript, page 8. This suit was against William individually and as trustee. That didn't change upon the withdrawal of counsel. Mr. Pace was entitled to, if he wished to, continue to represent himself individually. He just couldn't represent the trust without having an attorney. So the identity of the parties did not change. The judgment will be entered against both of them. And in fact, if the court looks at the final judgment that was entered in the case, it is clear from the final judgment that the $142,187 was entered against Mr. Pace individually and against the Earl H. Pace Irrevocable Trust, jointly and severally. Now, the fundamental issue that we believe we're in front of this court on is on the status of Mr. Pace as a party at the trial.
Now, we don't have a transcript of the trial, correct?
That is correct, Your Honor.
We don't know what was tried by consent. We don't know what stipulations might have been entered in by the parties. We don't know what was presented at the trial, correct?
That would be correct.
So how do we know that those parties aren't properly before the court because of some either stipulation or trial by consent?
What we would call to the attention of the court would be some of the preliminary rulings by prior to the trial.
But we don't know whether any of those preliminary rulings were somehow changed by something that occurred at the trial, do we?
Well, it's our position, Your Honor, that by virtue of the ruling of the order of November 13th, 2008, which is in the record at 174-75, the court ruled that the defendant, William E. Pace, trustee of the Earl H. Pace Irrevocable Trust, is the sole defendant, regardless of any other names under which he may currently be known. And that ruling was the result of several motions to strike pleadings that had been filed by Mr. Pace in his individual pro se capacity. It is also follows the motion to strike filed by Blue on August 5th of 2008, which appeared at the record at page 143, in which Blue stated in their motion that Mr. Pace individually is not a party defendant, a party counterclaimant.
But none of that overcomes the possibility that something could have happened at trial.
Judge,
change that lineup, correct? The parties could have stipulated at the trial that something came out and they said, okay, this person ought to be a party now, or we stipulate he's now a party again, or we move to amend our pleadings to orally move to amend to conform to the evidence, and based on the evidence, this is why we should have individual liability. That is at least a possibility, correct?
I don't believe so, Judge. And the reason I don't believe that to be the case is because if the court views what was done below on that order that I pointed out to the court and on the motion filed by Blue, Mr. Pace individually was dropped as a party. We start with the third amended complaint. Mr. Pace is clearly individually a party in that complaint, as well as the Pace Irrevocable Trust. So we have two separate parties. Now, there may be a more formal way that a party is dropped under our rules, but here the appellee clearly indicated that Pace individually is no longer a party in anything. So our contention, that's tantamount to a formal dropping of Mr. Pace as a party. The case law would indicate that when a party is dropped, the trial court loses absolute jurisdiction over that party, and a party cannot be brought back into a case absent personal service to bring them back into the case. So, in answer to your question, if you construe what was done as effectively dropping Mr. Pace as an individual party, nothing could have occurred at the trial by consent or otherwise to bring him back in as a party. The only thing is if the record reflected individual service had been done on Mr. Pace to bring him back. Now, that's important because if the court looks at the third amended complaint, which is what went to trial, the court will note that of the...
We don't know if the third amended complaint went to trial because we don't have a transcript. For all we know, there was a motion to amend to conform with the evidence, right? In which case they may have tried something other than the third amended complaint.
Well, all right, Judge, that's correct. We don't know.
I mean, isn't that the problem? You all have the burden in this case. You all didn't present a transcript. You all didn't present a stipulated statement of what occurred in lieu of a transcript, and doesn't that create great problems for you meeting your burden in this case?
If you reject the point that I am making, which is that Mr. Pace was in fact dropped as a party, then you're correct. But if in fact Mr. Pace was effectively dropped as a party, then whatever may have happened there, absent his having been brought back in through actual service process, and the record certainly reflects that that did not occur, could not have affected him at all.
But without a record, aren't you just asking us to speculate, guess?
No, sir. No, Judge. I'm asking you to review the record as to whether or not Mr. Pace was in fact, by virtue of the motions and the order, dropped as a party. And that doesn't require a trial transcript. So if your answer, as I say, is yes, the record reflects he was dropped as a party, then there's nothing in the record that reflects jurisdiction was acquired again, and it cannot be consented to. Consequently, the judgment, at least as to Mr. Pace individually, would be outside the jurisdiction of the trial court, and the judgment against Mr. Pace individually would be void. And we're clearly asking that if you agree with our position that he was a dropped party, and that the record doesn't reflect that the court regained jurisdiction by process of service, then that portion of the final judgment needs to be vacated. Now, it is, of course, our position that Mr. Pace individually was deprived of his ability to try the case by virtue of these rulings, these earlier rulings, and that consequently he was deprived of his constitutionally protected right to due process and to access to the court.
Is it your position that a trustee can represent themselves in court without an attorney?
Right now, Your Honor, we're addressing, the point I'm making relates to Mr. Pace in his individual capacity.
I've shifted gears.
I understand you have. And to the extent, well, I'm not really making that argument. Mr. Pace does raise it in his brief, and there may be.
So are you abandoning that argument?
No, sir. No, Your Honor. He suggests some cases that in certain circumstances where courts have recognized that a representative, such as a trustee, due to the nature of the trust that they are representing, or a shareholder that was coming in, there would be limited circumstances in which the courts have held that they are entitled to represent the entity that they are the representative of. If his brief is strong enough on that point in the case law that he's provided, we rely on it.
But wouldn't you agree that the law as it stands now is that a trustee cannot appear pro se on behalf of a trust?
I think that's the general proposition. There are exceptions.
It's also true that if he does, that may constitute the unauthorized practice of law.
I am not going to render an opinion on that, Your Honor.
And did not the court give him time to obtain counsel to represent himself as to the trust?
As I read the rulings, the courts were, the lower court was concerned with his getting an attorney to represent the trust, not getting an attorney to represent himself individually.
But he did have an attorney eventually come in and represent the trust.
That is correct.
And did he have any interest that was any different than the interest of the trust?
Possibly, we don't know. Had he been permitted to participate, he might have had interests separate from the trust.
He might have, but we can't tell because we have no record.
Well, that's correct, but if he was improper, if he was dropped improperly, well, you can't be dropped improperly. I mean, that's the plaintiff's right to drop a party. But the issue is, could they have tried the case without both parties having an ability to present their case? Now, the trial court, Judge Dugan, took the position that Mr. Pace was still a party, simply elected not to participate in a very active fashion. It's our position that Mr. Pace was not a party and was therefore precluded from acting in any capacity.
Can you point to that in the record?
Judge, the only place I can point it to is in the motions that were filed and granted.
But not the trial record because it's non-existent.
Judge, the order that I called the court's attention to, and let's see, there was an order entered on May 9th of 2008 in which the court altered the caption and style of the case and ordered that from that point forward the proper style of the case would be I believe that's the, let me see which order that is. Well, let's see. Yes, I'm sorry. It's record 174-75, the order of November 13th, in which the court set the new style of the case, in which the only party in that style is the William E. Pace, trustee of the Earl H. Pace Irrevocable Trust. Now, that clearly is a defendant that is the trust and not the individual William Pace. That ruling has some significance. I think it's a recognition by the trial court that Mr. Pace individually has been dropped as a party. And I think that's record evidence to support that position. Otherwise, that ruling means nothing. Now, the court may say it means nothing, but to Mr. Pace, it meant that he was no longer a party and therefore had no role individually in the case and could not participate in the case. Now, if that was not the case, if that ruling really, if you interpret that ruling not to constitute judicial recognition that he has been dropped as a party, and you conclude, as Judge Dugan did, that he still was a party, then we have a situation that was ambiguous, as for Mr. Pace, raised an issue as to his ability to participate at the trial, and again brings into question his fundamental right under the Florida Constitution to participate.
Well, we don't know if he he might have fully participated, right, for all we know?
For all you know.
Okay. Now, that ruling of November 13th, changing the style of the case, that would be a non-final, or a preliminary order, not a final order, correct?
I don't know if you're getting at whether we should have appealed it at that time.
No, I'm getting at the fact that the trial court has the right to revise its preliminary orders any time up till the end of the case.
Judge,
Do we know whether something happened at the trial which would have revised that preliminary order that you're now relying on?
without the record, no. But again, we are directly confronting the issue. If, in fact, that constitutes the fact that Mr. Pace was individually dropped, there would be nothing the trial court could do after that point, because the trial court lost jurisdiction over Mr. Pace, and any final judgment entered against Mr. Pace would therefore be jurisdictionally improper and void. So again, I mean, I think the issue here is, was he a party or was he dropped? And I see my time is up.
Thank you, counsel.
Thank you.
Thank you very much. Because you didn't file a brief, you will not be allowed to be heard. So we're done with the oral argument. Thank you very much.